I don't know why it starts our good morning, good morning, good morning. I am Bob Mata, and welcome to Defense Diaries. I'm your host, and this is our continuing coverage of the Commonwealth of Massachusetts versus Karen Reed. So we're back. We are back. Welcome in, all you beautiful human beings. We love you all. So we're trying to figure out. This thing's not going to get started right on time, based on the tweet that Aiden Carney sent out yesterday. We kind of got an idea of what Hank Brennan was talking about the other day, where he said he was going to be in the other courtroom trying to score Turtle Boy's telephones, his records for this case. So that Rule 17 motion is this morning in Doolin's courtroom. We've been trying to get the link to get in there, and the clerk says they're not giving it out. So I don't know if we're going to be able to watch it, which is shady. We should be able to watch it. But I do have Judge Canoni's courtroom at the ready in the event that that starts shortly thereafter. I am going to try one thing to see if by chance we can still get in. I'm going to try not to talk about it while I'm doing it because Allison hates that. And she's joining us. She's going to be joining us imminently. She does have a Zoom this morning, but it's only 8 here. It snowed again. First day of spring, I woke up to a bunch of snow. That's just great. That's just great. Not happy about it. Not gonna lie. It's the weather is so schizophrenic. Can't believe it. All right. So, but maybe when Allie jumps on, I'll have her try to do that. So we do have the one motion. So as everybody knows, Proctor was canned yesterday, officially canned. And I think everybody was pretty happy about that. It's like I was saying early on that it's hard to fire a cop for cause. So I knew it was going to take a hot minute. I mean, police unions, pretty stout. One of the tougher unions in the country, cop unions. So they're not quick to terminate people. So they will all right, hold on. I want to read a couple of things. One, I want to read the Proctor thing. You guys will just have to bear with me with the statements. And then we're going to go real quickly through the defendant's motion regarding the continuance. So today is either going to be very short. I think she's going to address the motion to continue first, is my guess. Wouldn't make any sense for her to do anything else. If she grants it, we're not going to get the rest of the motions in limine because I would assume that like depending on when she continues it. If she continues it to like the April 25th date, maybe she does do them. If she continues it out longer, then like I not knowing what the federal courts are going to do, it seems strange and seems like you're putting the cart before the horse for her to set a date for this trial, not knowing when that thing's going to get resolved. And I've been saying this since that was denied in terms of the federal habeas writ that that's got to get resolved. They can't move forward on this thing until we know what's what. I mean, it's dealing with double jeopardy and one of the, I think without question, the heaviest count, which is the murder two count. So I think we're going to really have to. I think this thing's definitely going to get continued. Which, you know, as long as it doesn't get set for the same date, um, as Koberger, which is end of July, early August. I'm thinking about going out there for that. Aw, what's up, Donna? Been missing you. Miss you. Thank you so much for your generosity. All right, so let me pull this up and we'll go through this motion real quick. This was filed yesterday. Or maybe what is today? The 21st? No, today's the 20th. Allie said today was the first day of spring. That's tomorrow. She must have thought today was the 21st. Hey, our little guy. Where's Mandy? Tracy, you in here? I don't know how to get that little guy out of there. How do I move that little guy? The cute little AI thing of Allie and I. I can't even tell who I'm supposed to be in that one. I can't I can't tell. It looks nice and old though. Okay, here. Let's see. Got a different overlay. There we go. Okay, look at that. See, some tech. I was feeling helpless, and then I wasn't. All right, so this is the motion that was filed yesterday around 10:40 in the morning, and it is the defendant's motion. Defendant's assented to motion to continue the trial to a date on or after April 25 of 2025. So now comes Karen Reed by and through undersigned counsel and hereby moves this honorable court to continue the trial in this matter, currently scheduled for April 1, and to go through April 28, 2025, with a pretrial conference date on Friday, April 25th of 2025. So the defense respectfully submits that such a continuance to which the Commonwealth assents, which means agree to, as further noted below, is necessary to permit Ms. Reed to appeal the denial of her federal double jeopardy claims, which the federal district court expressly found to be, quote, substantial to the First Circuit Court of Appeals prior to being forced to undergo a retrial that Ms. Reed contends would violate her rights. So on June 9th of 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder, or I'm not supposed to say that. I think it does. I think that whenever I say that word, they put a brick. Algo punishes me. Manslaughter while operating under the influence of alcohol and then leaving the scene of the collision resulting in death in violation of. So a jury trial began on April 16th of 2024. This court declared a mistrial on July 1 of 2024. After the mistrial, Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds on August 22nd of 2024. After oral argument, this court issued an order denying Reed's motion to dismiss. On September 11th, 2024, Ms. Reed filed a petition for relief with the Supreme Judicial Court pursuant to Mass General laws. On September 19th, 2024, a single justice of the SJC reserved and reported the case without decision to the full court. On February 11th, 2025, the SJC issued an opinion affirming the denial of Reed's motion to dismiss. Ms. Reed then filed her federal petition for habeas corpus on February 18th of 2025. And then after oral argument on March 13th, 2025, the federal district court denied Reed's petition. Before denying the petition on the merits, the district court found that Ms. Reed properly brought her petition under 28 U.S.C. 2241. Two, that she satisfied the custody requirement to bring a habeas petition. And three, that she exhausted her state court remedies. And four, no abstention doctrine barred the federal court from considering the petition. So the district court granted a certificate of appealability, finding that Ms. Reed made a substantial showing of the denial of a constitutional right as to all claims. Ms. Reed filed a notice of appeal the same day that the district court denied her petition. Pursuant to an expedited briefing schedule agreed upon by the parties, Ms. Reed filed her opening brief on March 18th, 2025. The appeal will be fully briefed by March 26th, just 4 business days before Ms. Reed's scheduled retrial, that is. As the United States Supreme Court has observed, the rights conferred on a criminal accused by the double jeopardy clause would be significantly undermined if appellate review of the double jeopardy claims were postponed until after a conviction and sentence. It is a guarantee against being twice put to trial for the same offense. That comes from Abney v. U.S. Obviously, and this is a quote, these aspects of the guarantees protections would be lost if the accused were forced to, quote, run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted or if convicted, has her conviction ultimately reversed on double jeopardy grounds. She has still been forced to endure a trial that double jeopardy clause was designed to prohibit. Ms. Reed respectfully submits that double jeopardy protections at stake in this matter are simply too important to force her to stand trial for red rum, in what she contends would be a violation of her rights for having the opportunity to appeal her substantial constitutional claims. Moreover, whether Reed's retrial will proceed on all 3 counts or be limited to count 2 will materially impact her trial counsel's strategy and decision-making, such that the defense believes Ms. Reed is entitled to know which counts she will be tried on in advance. Commonwealth assents to a short continuance of the trial date to the end of April 2025. That assent is without prejudice, and the Commonwealth expressly reserves the right to oppose any further continuance or delay of the trial, including if the First Circuit appeal has not been resolved by the time of the new trial date. For the foregoing reasons, Ms. Reed respectfully requests this honorable court continue the trial in this matter to April 28th of 2025 or the first available date thereafter. All right, so that's interesting for a couple of reasons. So it looks like they are only seeking it out to April 25, or at least that's what they could get Brennan to agree to in terms of a short continuance. So maybe she will hear. So maybe she grants this, kicks it to the 25th, and they will go through the other motions in limine that are still pending. We probably had, I don't know, 10 or more left to go through still. So I guess we'll find out. Let me double check and make sure that thing hasn't started while I've been reading. No, it has not kicked on yet. Let me check another spot too. Just double check. See what these guys got going on over here. All right, let me see. Yeah, they don't have the camera up and running in there either. I mean, they're not gonna start it till the thing is done with Brennan in Judge Doolin's courtroom. So, all right. I wish Allie would get on so that you guys aren't sitting here while I'm silent. But it is what it is. Let me see if I can get Allie sent me. All right. I'm gonna see if this works. Yeah, that did not work. I don't know about this. That's Zoom for government. I find that to be scary. Very, very scary. So I'm not gonna pull that one up. Plus, I didn't even see the link to. I try to even get in. All right. Okay. Tracy, were you guys talking about? I did want to pull up. He has the hearing up. Is it going on right now? Pee Wee? I don't know his what is his channel name? Throw it in the chat. Oh, Long Crime. Let me see. You guys are awesome. Let me see. Okay. Oh shit, you guys are right. All right, I'm gonna rewind it. Thank you. Thank you, you beautiful, beautiful humans. All right, let me get this thing. All right. Awesome. You guys did amazing work right there. It sounds like they were a little bit late getting this thing fired up. All right. We found it. Chad found it.
The
Those are
link didn't
awesome.
work?
Nah, that was like a government Zoom, man. That was not the one. I don't know what that was. Okay. All right. So it looks like I'm going to put this right to when they go live, which is right here. So it sounds like they were a little bit late.
A Commonwealth
See,
lawyer specifically.
Just so you know, they were late getting it covered, but
see any case law that specifically says under these circumstances.
Wait, maybe we can hear it though. Maybe not. I was trying to see if they were doing audio only for a hot minute, but it sounds like when they just went live, they just went live.
That specifically says.
All right. So this sounds like about it.
See any case law.
Just play.
I am, honey. It's cycling.
Oh.
And I'm not going to bloop.
See any case law that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Carney's case. Because of that, I have from the beginning kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant.
Oh, there is a search warrant.
As well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are two phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party.
Oh, you watched
then
a
be sent to-
Counsel, let
documentary,
me
did
stop you
you?
there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes.
Yes,
As
please.
Your Honor is aware, conscience of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney,
So what?
in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then
So
be
what?
reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there
Because I said
is
so.
extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in
You're
support of the
done.
search warrant thoroughly. And here's where I struggle.
Yeah. Heard that coming.
So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant.
Fishing
That's the initial
expedition,
burden.
Yankee.
So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Carney, so I'm asking that Mr. Carney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Well, we're a little confused. And I don't
Did you
mean
see
to
Karen
proceeding,
looking at
but
Hank?
as we're-
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called. If it was Rule 17, if it was Mr. Carney's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannone, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue.
It is,
meeting is being
counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
What?
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Carney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay,
That's correct.
then she needed to be here and she has a right to counsel and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in
This is
terms of her,
awesome.
I mean, this is her case.
This is,
I don't know that
This is
that's,
awesome.
yes, it is her
I was
case,
like,
but
I
what
need
standing does
popcorn
she
in my-
have to challenge a Rule 17 request related to documents produced in another case?
it's
because
his it's her conduct, it's
Specifically
her
pertains to
data.
the prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we,
which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues, which are not
her
before the court. All of it before
content.
the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This
understand,
is,
Your Honor, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the admissibility standpoint, that can be dealt with at a later time, but the case should never be
Threshold.
called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to
I think
Ms. Reed's
David
rights. And
David
it's
should be
her case
arguing
number.
this.
And the
That's
reason
common.
Commonwealth is trying to
Agreed.
bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
counsel,
That's all.
counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit
Orally.
oral argument as it attends to, and we're
And did you
prepared.
give the court notice of that?
We did to Justice Cannone,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little
That
is
ship
prepared to
sailed.
address the court on the very issues that Mr. Brennan is bringing.
I'll take it under consideration.
Pause it
Is
1
there any
second,
issue,
Dave. Pause it 1
counsel,
second.
with the current configuration, the court, such that that causes any?
All right, and then when we start, go back 10 seconds. My position is this. He has a threshold. The judge just said, how are you going to prove relevance? I think she still has the right, as they're trying to uncover evidence against her, no matter who it's from, to say he hasn't met the threshold level. Now, also, the person whose data they're trying to get has a right. But I also think, I mean, isn't it, he literally said the words, you're looking for communications between Karen Reed and Aiden Carney, which I didn't understand. Wouldn't they have all those communications from Karen Reed's phone? But I don't know why he's not making that argument. If part of what Brennan is asking for is communications between Carney and Reed, Reed has a constitutional right in of privacy in her content.
Yeah, well, here's the thing. I think this judge was on the verge of denying it.
Right.
So, which obviously they did not know when they stormed the castle. which was awesome. It was awesome. They came in. In my humble
Why they
opinion,
show up a half hour late?
I don't know. In my humble opinion, I think Dave United should be arguing this just because he's a Commonwealth lawyer, probably more familiar with these particular. I mean, they're not going to have Rule 17s out in LA like the Commonwealth. They just have different laws in different states. But that being said, I was getting the sense that the judge was getting ready to shut Hank down. And now he's like, well, because judges won't clue you in as to what the ruling's going to be if you start piping up like prior to them giving the ruling. So he's not going to say, yeah, I mean,
You
he
were
might give you
better off
hints.
right. But I was just going to say he also might have just been looking for it to be pared down, to be not
Excuse
so
me.
vague and overly broad. All right, back it up and start it.
All right, let me go.
Like 15 seconds.
The issue for consideration.
Is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Radel is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The council wants to join in my filing. That's an issue in terms of the filing. So, just put it
Thank
down.
you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion
I
of third party.
disagree.
Great.
She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at council table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and
Sit
her
back down, everybody.
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue,
She's
as
right to be
I
present
see it,
anytime her case is called.
with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed
How?
case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is.
Hey, Brennan, let me stop you again. Would any of those categories include communications from
With Karen
Mr.
Reed?
Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Carney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the 2 phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth v. Kearney case, docket number 53, Commonwealth revised proposal for examination of digital materials seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of
Pause
the
it a
fact
sec,
that this
babe.
information was seized pursuant to a warrant of probable cause, in light of the proffer in the
He's
affidavit.
trying to latch on to.
I told you he was going to do that.
No. I'm not talking about that. I get that. I thought he was saying in the Karen Reed case, there's a warrant. I can't tell if he's trying to latch on to the warrant that allowed the court in Kearney or the Commonwealth in Kearney to get his data, because as we both know, and hopefully all of you out there who are, at least subscribers to this channel, a warrant is particularized. So just because there was probable cause to get it for the purposes of searching for evidence against Kearney of witness intimidation, does that now say there is probable cause to search it for a completely different reason to establish consciousness of guilt evidence against Karen Reed?
Yeah, which, if people are wondering, they obviously had impaneled a grand jury trying to add witness intimidation charges against Karen Reed, which they did not return a true bill of indictment. He's arguing for something different. So now he's not seeking to continue to try to add charges, which ultimately he would be, though. I mean, to me, he's trying to make a roundabout argument getting at the same thing, because he's saying that it's for consciousness of guilt, but he's really trying to look for the exact same evidence that they would have used had they been able to get a true bill for the witness intimidation charges. So,
and just so you guys out there know, so for whatever reason, they handled it this way, where Brennan had to file this motion in front of the judge in Aiden's case, even though it is filed under the docket number in the Karen Reed case. So typically what you would see, and we saw it with the media, you file it in your case, and then that witness has the right to come in, unless 17 is different than what they did, when they were trying to get the notes of the reporter and all of that stuff. And then that person comes into your courtroom in front of your judge and asserts their rights. Never, ever, ever should a criminal case be called ex parte, ever. It's an ex parte hearing. I don't
100%.
understand. I don't understand what they're talking about. Even if they decided, which I disagree, but even if they decided that the evidence that that she has no standing to speak on this issue. She nonetheless has a constitutional right to be present every single time her case is called before any judge. Um,
I don't see in what world Karen Reed doesn't have standing to be heard on this matter.
I don't either.
It
Because
directly
again,
impacts her case. It's called under her case number. I
right.
don't understand unless I've completely forgotten what standing is, which I have not. She absolutely has standing.
She technically might not have standing to object to them infringing on Aiden's rights. However, when you get to that like threshold matter of relevance, she should definitely be able to make the argument against it for the purposes of how is it relevant. And it
Well,
is, like you just said, a fishing expedition against her.
yeah,
They
and
could use that evidence against her. Go back for, to the grand jury with new evidence.
yeah, but he's not seeking. This isn't pertaining to Aiden's case. I mean, it is generally, but in terms of what he's seeking it for, it's for Karen Reed's case.
Right. No, I understand.
So, like, I mean, they're not trying to get standing in Aiden's case. They're
I
claiming
know.
that I don't understand. Like, she has standing to be heard. That's my opinion on it.
David, in light of Ms. Reed's admissions of, and so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, inevitably, the obvious consequence to witnesses, this is relevant to consciousness of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding consciousness of guilt. Also, will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Carney's case.
He hasn't said one word about how it establishes consciousness of guilt.
Videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Oh, what?
Oh, no.
Good God.
Oh, I got
Morning, Your Honor, counsel.
Morning.
Thank God.
Judge,
Damn it.
this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something, and I was prompted to write this press release that I sent out about this exact issue. And I went back to it. I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants, and talk to anyone she wants, and communicate with anyone she wants, and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and fail. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this, and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phone, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in
So-
Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have.
So how
the
does she
idea
not have a
that
right, a
they
privacy
communicate.
right?
The fact that they communicated cannot be a basis for a criminal investigation and the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in 88 Special 88 cause.
Subject to the limitations of the warrant.
It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones we're going to ask for husband-wife communication.
Counsel, you're not asking.
No, not you. Just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for that journalist source materials,
He's
of
married?
which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So ADA Brennan, before I hear from you any further.
And hook was the appropriate word because this is nothing more than a fishing expedition. Nothing more than Brennan has no particularity at all in terms of what he's looking for. Again, and I said it 2 days ago that Brennan was going to walk into court after I saw that episode wherein they showed text messages between Karen and Aiden talking about them talking to Alan Jackson. You know, they had it aired. I was concerned yesterday, and I said it on the live, that, you know, Alan Jackson had just stood up in front of Canoni and said, we gave no direction whatsoever to Aiden Carney to do anything with respect to, you know, him intimidating anybody. He did what he did on his own. So like, you knew that Brennan was going to be coming in with this shit. Thankfully, the judge is like, I don't need to see it, but this amounts to nothing more than a fishing expedition. Nothing, like, there's nothing here that he has been able to articulate. And again, like the concept that we already know that a grand jury was impaneled and looked at this stuff. I mean, like to me, it's already been litigated. They've already put it in front of a grand jury, and that is an exceptionally low burden. And it's the same type of information. If there's
they're not
information
looking for evidence of a
guilt,
right.
yes, it is.
They're looking for evidence of what you just said, consciousness of guilt. They're not looking for evidence of a crime. However, their whole, like you're saying, what makes it consciousness of guilt is because it involves intimidating a witness, which is a crime. But I'm just saying.
No, what they're saying is it's consciousness of guilt because if at all she's asking, this is what the Commonwealth's argument is, if at all she is asking him to intimidate because for any reason that makes it look like she's guilty, that she has to employ other agents to get out there, stir up the shit in order to help her get exonerated. So,
Right,
I mean, it's the same. Yeah.
Again, right. So at the end of the day, it's the
It's the same
involvement
shit.
in intimidation that would make it. I don't even think, even in my mind, even if there was evidence of intimidation, that is not consciousness of guilt. Could it be, I don't, like that there's, I guess, some sort of low level thing that they could make out, but I just don't think that it's like saying there's not a whole new privacy invasion going on here. When you get a warrant, it says you can look at data for this purpose, looking for these things. It doesn't give you the right to just re-review everything, looking for under a whole new umbrella, under a whole new scope. And that's what I don't understand, why that argument isn't also being made, that it would be a whole new intrusion. So they get somebody's they can just go back through old protected data that was allowed to be searched for a very limited purpose and be like, hey, maybe we missed something there, and there's some evidence of another crime that we did not notice immediately the first time. You can't do that. It's like saying that you get to open the drawer in the kitchen when you're looking for, when your search warrant says you can look for a television.
Right. All right, let's get to it.
In response.
We will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradel. Apologies, Your Honor. There are.
Got thrown off.
Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel.
Granted, it should be
Gideon
in
Brennan, I'll hear
chambers,
from you in response briefly.
in camera inspection by a court to decide if it's relevant.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradel. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
that is not entirely accurate.
Yes,
There was
it
a
is.
motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed.
This is
I agreed to
outrageous.
that because I won't
Articulate
instruct the
it,
witnesses
Brendan.
unless the door is open and you have an invitation. That would be
He needs to explain that like we're 5 years old because they're
Right,
one and the
because-
same. They're one
right,
and the
because-
same.
What the hell consciousness of guilt is he looking for if it's not intimidation? And how come he hasn't said the words? Your Honor, this is what we are looking for evidence, the possible evidence that could come out that would establish consciousness of guilt is what?
Right.
And
That's what I'm saying. He's got
how-
to say it. Is he looking for a text where Karen says,
I did it.
I did it, I hit him, you got to
Because
help
that's
me
a
out of
fishing
this
expedition.
jam?
There is no reason to believe there's anything like that there.
Thank you. That's what I've been saying.
proper.
That's what we're all
Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to
Why
the
is
state
no
of
one
mind.
asking
The
this?
consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed?
Such as?
We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids are. Yes, exactly. Right.
How is it any different from someone who gets a search warrant saying a week later, well, I need to go back out and research that house? You can't do it. You know, I seized the computer, okay? A computer's warrant, the affidavit for warrant, and the specificity of what can be searched is confined to to certain parameters and for the search of specific information. So you can't just be like, well, they already have the computer that they got for a completely different purpose under completely different parameters. So now I just get to look at it whenever the hell I want. I just don't understand why no one made that argument.
All right, we're
That
getting right to it. I agree. I
and
obviously
consciousness
agree.
of guilt is too vague if he can't put to words like you were saying. What are you looking for? What's this?
I mean, like it's Ipsy Dixit. He's just saying shit again. Like he says things that it's not the same.
Is that
the
Lally?
Yeah, they're getting ready. They're already up. So
They've been doing things?
no.
Oh.
Cannoni's just taking the bench right now.
Oh, we were behind time. Okay.
Just
Your idea, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor.
Oh,
Robert.
I got it. Now I can go to Zoom.
Avalon for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Yannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all 3.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance, and I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well,
April.
I'm not going to grant the motion.
Wow.
All right. We
Oh.
have jurors coming in
Wow.
that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right, so let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it.
You're going to be doing Reed.
So
and
we
I'm gonna
did
be
hear
doing
from people
Abel.
this morning. I know you all have, I have it. I have it, Jim.
Thank you.
I think Mr. McDermott gave you a copy of
I'm going to go out there for a week.
I guess
think.
what local merchants have requested.
We've received it. Your Honor. Thank you.
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information,
Can't you just say we
that
rely on our papers?
noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar
think
with
this
the
appeal is
Dedham
gonna
area.
help at
It
all.
seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take that position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Can I just have this marked for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Is that us?
What?
In that little picture, I was trying to figure out who it was. I'm like, wait, it's AI us.
I don't know what AI image it is.
You and me, babe.
Your Honor, could I be heard on
that.
that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll
Okay.
happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Just do it under a protective order.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that.
Right.
I still
No
need
one's got a
cities and
problem with
towns.
Of course,
Okay.
yes.
It's what you should have
right.
done to begin with, Jagoff.
Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
This is the one I really want to hear.
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. And the Commonwealth opposed it.
She meant to ask who's arguing.
You had
for
asked
the
who's
defense.
arguing that for the Commonwealth. That's why.
I'm sorry, defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the.
I'm fine with him going first if you'd like.
Okay.
Makes things quicker.
Hank and his binder. Trapper keeper.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government.
Correct.
I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the
As
time
they
they
were.
wrote the report.
As they were.
And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report.
All accurate.
I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed.
So what?
We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they
No, sir,
were
it's the truth.
independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective.
It was.
Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was.
Oh, I didn't know that.
There was DNA, and separately, there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned, as they should, well before trial, in my opinion. We do not have the opportunity to question the United States Attorney's Office. We resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report
He don't
is
have to tell
vague.
you.
And so it doesn't
He has no
identify
right to
or
know.
articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
The prosecution has no right to know or inquire as to why the defense did not call a witness. That is no.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions.
But did you provide?
But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Jeez, Bev. Judge Cannoni.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation.
Yeah, but the jury, in all honesty, is going to speculate why the DOJ hired them. I mean, like there's no escaping the jury speculating. Even when you tell them they were hired by the DOJ, that's going to make them speculate, well, why? I mean, there's no avoiding the speculation aspect of it. That being said, the jury needs to know who hired them.
I mean, but if she at least makes it clear that, look, you've heard this evidence that they were hired by the DOJ. The last thing I want you to do is speculate as to why. I can promise you it's not relevant. It doesn't matter. It's only for the purposes of you understanding that they were not hired by
either side.
Right. And then at least they're not speculating that it was somebody motivated to help Karen Reed.
Yeah, no, I'm not giving the jury too much credit, Lita. I'm saying they're going to speculate. I mean, we know they are, no matter what they're told.
Just as they did here,
right.
Despite being told. But I think that being told it in that way, in a more upfront way that makes sense, might make them be like,
she gives that same limiting instruction or admonition that they're not to speculate as to why they were hired because it's irrelevant. It doesn't matter. Yeah, I mean, there's an easy workaround. They have to be told. They have to be told who hired them. It's the damage, if she doesn't allow it, is much greater than the damage if she does allow and they speculate as to why the DOJ hired them, in my opinion.
Whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA, and they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination
100%.
material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes.
He shouldn't get follow-up. It wasn't his motion.
Right. Yeah. That makes no sense.
Respectfully, the Commonwealth does not look to hide the truth. The reality is if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction,
They
scope,
need to know what their
purpose.
directive was.
We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know. Now,
They were
I hear now
investigating the
that
Commonwealth.
Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023 describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right.
Yeah, they do.
So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later. All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in, one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that, we have a jury sitting for weeks at a time away from their families, away from their jobs, and any, sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection. And I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied.
Wow.
So the next motion,
She can
defendant's
rule from
motion
the bench.
eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay,
So we can agree to that motion.
all right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Lisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a
change.
new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't know. I thought I'd just say it, Your Honor, and then you do it.
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that
We know the concern, sir.
many of the
That's why we
sidebars
asked.
help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information. whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion.
Political.
It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, two photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan. Paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Como versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right,
It's
who's
not-
arguing this for your
It says
defense? Ms. Little?
undetermined.
Thank you, Your Honor.
It's not, there's no liability in undetermined.
In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the
Because,
word
you know, it's the
homicide, because
defendant's
it
right
violates a
to a fair
defendant's
trial.
constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability.
Right.
That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorti-Bello. Oh.
Not on their witness list.
And they're not even saying anything. They're just sitting there quiet.
Hold on. Let me check that.
There's Lally.
But they didn't make a conscious decision whether to exclude her. I mean, why aren't they saying, we plan to call her, we might have messed up?
She's number 81 on the Commonwealth's witness list.
Oh.
That would have been insane.
I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick, so that's paper 580, Jim?
Thank you.
Commonwealth's motion eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Your Honor?
Sure.
I was going to say, is there an objection?
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a Corey check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having Said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation
Whether they
of
think it's
jurors
important or not, if they
be
looked
turned
at it.
over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
They have to do it.
Is it the common practice of this office?
He's like, look, it's in the thing. I look in
Brennan
the
asked,
binder.
is it?
Valley's like,
Your
in the
Honor, is the
binder.
court's question common practice of giving everything, or is it common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record and re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. And I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial, there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you
But
give
I
the
thought-
jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
Well, she said she'd be surprised if she granted the motion to allow the information about the ARCA witnesses. So
Wait, what did she say?
she would be surprised if I grant this, and I'd be surprised if I granted it. Yes, Aiden and Karen were together at 9 a.m. We all watched it. Thanks, Kaylee. Happy to have Donna lurking. She's lurking. Glad to be with friends. Thank you for your generosity. Cool lady. Family hugs. Bob, Allie, Mods, and everyone. Thanks for your generosity.
Aw.
Deja vu. 13 months. Jay's here? So he said?
Yeah, he's
Hey,
right
Jay.
there.
He's right there.
He is. See him right there at 10:03 saying, hey, Spitfire.
I was looking at these, so I wasn't in that screen. Thanks, Idiot Win, for your generosity. Like the stream and appreciate, because we all do, family. I love it when you guys use a super sticker to remind our viewers to do something that benefits us. So thank you. Cami Q gifted 10 memberships. And so thanks for your generosity, Cami. And Terry has been a member for 4 months. Love being part of the fam. Rants are approved. And Lisa, she wants some puppet action. Bob, could you please use the puppet when Hank speaks? He provokes me to slumber. I need more puppet. Thanks
I
for
have
your
to get
generosity.
a Hank puppet.
He could be Gacy.
No. No, he's very like I'm no fan of Hank Brennan, but he's no John Wayne Gacy.
I just meant the puppet could double.
Oh, yeah. Yeah. So based on what we've heard,
Wait, how long did she say we're taking a break for?
I think it was the morning break, so that's probably 15 minutes.
All
I
right,
don't think
well,
I don't think it was the lunch break. I'll see how much time we got to bloop. Bloop, bloop,
well,
bloop,
how
bloop,
come we're
bloop, bloop,
seeing
bloop,
that
bloop, bloop,
weird? Oh,
bloop, 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 bloop. Seeing what? OnlyFan? It's OnlyFan.
no, there was a whole different thing on the screen a second ago.
Oh, I don't know. Yeah, we're live. So we got a hot minute. So what was the most annoying, repugnant decision that she's made? Now, she took many of them under advisement. To me, the objection thing, I can't with it. Like there is no reasonable explanation as to why she's just not allowing them to state the basis of the objection. It just,
I told you he should have said, well, if that is the case, then the judge it needs to be the judge. So we were watching the um Lori Vallow case the other day. So if any of you were here, but she's representing herself. So she cannot walk up to the judge and hand him paper. She can't walk up to maybe she can the judge, but she can't approach the jury. So she can't show them evidence, she can't hand them something. So the judge said, which is the way it should be, that the state is going to have to take the same thing, like whichever lawyer is doing the examination, another lawyer is going to have to approach and hand something to the clerk, and then the clerk will give it to the jury so that it looks to be the same. And there's nothing to be taken from the fact that, oh, she can't even approach us because she's so scary and dangerous. What the judge could have done here is say, okay, I am going to say, someone says objection, and I'm going to be the one to say for each and every one of them, please approach.
I mean, it's,
And that's just going to look like it's the judge's standard procedure. No matter who objects, everybody approaches. And then it's not like the defense having to say, can we have a sidebar? Can we have a sidebar? Can we have a sidebar?
it doesn't really cure the issue though. Like I
No.
understand for judicial economy and for the purposes of not annoying the jury and putting that annoyance on the defense because they're requesting the sidebar. The issue is that the defense doesn't know what the hell the basis, or the Commonwealth for that matter, doesn't know what the real basis
Well,
for the
that's why
objection is.
every single time someone says objection, they walk up and then they say the
I
basis.
understand that.
Oh.
I understand. I understand that. It makes zero sense to me. Because I mean, Lally was just objecting constantly. I mean, as an attorney, if you don't have to come up with the basis, like in that split moment, like
Well, that's not what they do, though. That's not what they do. So you know what? Now that I think
wait,
about it,
are you just saying that, or do you know that?
no,
as a
I
fact?
heard Judge Cannoni say the words that this is the way they do it. So, because I was shocked, I was like, "What? That's the way they always do it?" I thought she was doing something special.
I mean, Yannetti
There.
practices. I mean, are you mean in this
Well,
courthouse in
yeah,
particular?
right, right.
In
I
Dedham?
can imagine that they do that in Boston. You
That
know,
would be
that'd
that
be
would be insane.
outrageous. But
Outrageous.
let's say, okay, for example, they stated their grounds. Now, several times that might be enough right there, and they can kind of shift their answer. But often, more often than not, I would suspect, like unless it's like lack of foundation or no, leading, you know what I mean? Then they can just fix it, um, or to the form of the question, then they can just fix it. But if it's something like hearsay, anything that has an exception or requires something substantive, then I mean, I guess that could be a thing too, where I was going to say, then they would still need to approach. The defense would have to say, well, we need to approach so I can say why it's an exception, right? So they'd still have that thing where they're asking for a sidebar. I was going to say maybe a workaround for that would be is if they said, okay, if the objection is, to the form of the question, leading, whatever. They could identify the ones that they don't need a sidebar for, or identify the ones that they would need a sidebar for no matter what. But she's not letting it happen anyway. So
Yeah. So Akasha, when you use the word impounding, are you talking about why are we not allowed to hear it? I mean,
no,
when they
she's
do,
asking about the motion was apparently the first trial, the parties agreed to seal sidebars, meaning although it's always outside of the presence of the jury, it would be a part of the public record
right.
that could be ordered when you order the transcript. So apparently, like I said, in the first trial, they both agreed. Either way, it has to be outside of the jury. Always has to be outside of the jury. It's the whole point of having a sidebar so the jury doesn't hear something that they shouldn't hear, so the lawyers can make arguments that the jury shouldn't hear. But Brennan was saying he wanted them impounded so that at no point could the public, when they get the transcript, know what was said at sidebar, and that's ridiculous.
Yeah. I just,
I think
I'm trying to think it through. I'm trying to think if there's a rational reason as to why, whether it be this county or multiple counties in the Commonwealth, do not allow them in front of a jury to state a basis for an objection. Is it like potentially that they think that gives the jurors some kind of feeling one way or another? Like when they use these words, whatever the basis may be, that
they do it in every courtroom across the nation.
I
So
know. I'm trying to understand it. Like I'm trying to understand any kind of rational explanation as to why they would do that.
right. And just to go back to the sealing the sidebar, yeah, Julie is completely accurate. Brennan was arguing that, but I don't know how long it's gonna. I mean, it's not like people would know right away. They'd have to get the transcript. Or she's not suggesting that the public gets to hear it somehow, and while the jury doesn't. So I thought that was an argument that he was making, that um, you know, something that was said at sidebar would get leaked to the jurors, but I don't know how the public would hear about it until a transcript was ordered and delivered.
Yeah. Um. Yeah. I don't know. I mean,
And thanks
there's
for your
just
generosity, Akasha. Sorry.
so. What is your? How do you feel about both arguments with respect to the concept that the jurors be informed that ARCA is hired by the DOJ? Like,
So I
do you think there's any any teeth to Brennan's argument that if you tell them that you have to go all the way?
Well, I would define all the way. I do think if you tell them that, right, that they have a right to know what parameters they were hired, because what if they said, well, the government told me that they wanted to find out, that they were investigating and they were hoping to find that the car didn't hit the people. They were hoping to find the police planted something. They were, like if there was something that I can't imagine that happened. I'm assuming the answer is going to be they didn't tell us. And I thought, you know, I think they could still be asked that as part of your the scope of your thing, and they might have been asked something similar to this during the trial. Were you told what the outcome should be? Were you given, any directive as to what hopeful outcome was coming, or the reason that they,
See, 'cause I
um
mean, you and I were talking about this off pod the other night, and I mean, we all know that this thing was born out of the Sandra Birchmore investigation, and then the motion to dismiss drops. They see that there's bleed over between the two departments. It's the same, or both cases rather, that you've got Canton involved in both, MSPs involved in both. Um,
right, they were investigating
but what
potential
I
police
mean, like
misconduct.
in order for them to, what I'm suggesting is that they had to get the analysis from ARCA when they're retaining ARCA, who is a private company. It's not some government company. They hired this company for one purpose. They're not going to give them, I would think they wouldn't be giving them any information as to why they're hiring them other than to answer one question. Was the damage that was evident on Karen Reed's Lexus caused by it striking a pedestrian.
And the
Period.
counter question was the injuries on.
Correct. Like, because until they get a decision, and they went no further in that investigation, I imagine that was the very first thing the feds did, if they're being prudent, is okay, well, first, before we even dig into this shit, we need to find out if, in fact, the vehicle damage was caused by it striking a pedestrian. And so if they get the answer, yes, then I think their investigation is over, because then they don't need to look into, all right, well, if the answer is no, well, now we've got to kind of look into what the defense is saying here as far as third party culprits. So in terms of what ARCA knew, I don't think that they knew anything. I don't think that the
Right.
feds don't share that kind of information with anybody,
Right.
let alone some kind of,
Third
company that
party.
they've hired to do a very specific task.
Right. That's
So-
why I think that you could resolve Brennan's issues without all of that. Just literally, did they tell you? And they could, and I think that would be appropriate at voir dire. Personally, did they? What were your parameters? What were you told to do? What information, factual information, were you told about what type of scene you were even investigating, or were you given a purpose? And like you're saying, I suspect the answer is going to be no. We were just told that they want us to, make this determination without any facts, not their suspicions, not what they were hoping to gain from it.
Yeah, I
And
mean,
if that's the answer, they never needed to discuss anything about,
Ever.
oh, the federal, it was investigating the police corruption. It was
they're
investigating.
never saying that.
And the DOJ is jurisdiction is very big, as is the United States Attorney's Office. And people are hearing that in the public these days, because you're hearing about so many things in the political spectrum where you're like, oh, the DOJ is involved in that. The US, so it doesn't translate to it's like the FBI was a federal investigation, you know what I mean? So I think that Yannetti is accurate, that you can just say the DOJ or the United States Attorney's Office and not tell them for what, for what purpose. And it solves the problem of at least them thinking that the person is motivated to come back with something
Right,
beneficial for
that's
Karen Reed.
what I was saying before. I mean, like the damage that's done by not telling them at all is greater than by telling them and still
that's-
like they're always
I don't think
gonna
they made the
speculate.
argument as well as you made in that sense about the balancing of the two. All right,
Right.
let's
I mean, like, because that's the thing, right? I mean, ultimately, at the end of the day, what matters most is Karen Reed's rights in this situation.
and restate it, because I knew where you were going, and I cut you off. So explain it again to the
You
people.
interrupted me. I don't
Oh,
believe it.
I might have.
I mean, it's a pretty simple concept that frankly, if you tell them, okay, them being the jury, okay, this is who they were retained by, and leave it at that, they're still going to speculate. Okay, like, we are human beings, we will always speculate about everything. So they're going to be told that, they're still going to be wondering, well, why were they hired by the Department of Justice? What I'm suggesting is that is a less greater harm to Karen Reed and her rights than the opposite, where they're not told anything, where they are, and we know for a fact, at least from one of the jurors, that they began to think that they were hired by either Karen Reed's insurance company, something related to Karen Reed, that it wasn't related to the criminal case, but it was still hired by the defense for some purpose relating to the accident. So, which is a much greater harm to Karen Reed and her rights. So, I mean, to me, you take that chance, because, and again, and I saw this and I wanted to ask you, because it was a good comment in here with regard to the DNA in terms of the biomechanical analysis of whether or not the damage was done to that vehicle by a pedestrian strike. The presence of DNA has not a goddamn thing to do with it. This is physics. Like,
Or if
it
they could
doesn't
determine
matter.
it wasn't blood, but if it was blood,
That still wouldn't matter. There could be a million reasons that John O'Keefe's blood was on that taillight that had nothing
right.
to
But
do with
if
that.
their report said that they considered the fact that there was no DNA and then there was DNA, what you do is you ask them on cross, assume there was DNA found.
I think they did.
Right, I think they did too. Right.
I think Lally asked that.
But
Like, 'cause
that's the
Lally
appropriate response, and then it's like, would
right,
that change your, you know
right, and Rensler said no, because it wouldn't. Like, in terms of the physics of it, the presence of DNA or a hair or anything else has nothing to do with the physics of it.
Right.
I mean, that's a circumstantial evidence type of thing. That's for a trier of fact to figure out. That's not for biomechanical engineers that are trying to determine using physics and the laws of physics as to whether that damage could have been done. Yeah, I don't know. I don't know.
Kinda
I'm
hard.
arguing with Rich Schoenstein on Twitter. He's like, "Oh, that was the most ridiculous request of all time by Yannetti."
Which?
Like the
ARCA?
what we're talking about. Yeah, that are that they that the
Is that a
federal
lawyer talking?
yeah, I
Oh
had
my
Rich on with Josh. He's like they were hired to look into the third party culprit. I'm like, what the fuck are you talking about?
That's not even accurate, is it?
It's of course it's not accurate. We
Right.
just discussed that. How could
I
it
know, I was
like in
like
what world is ARCA being ever retained to look into third party culprit stuff in a criminal case ever?
Right.
It has nothing to do with that. It was the first step for the DOJ, but ARCA didn't know that.
Well, not into third party culprit, into police misconduct specifically, right?
Whatever the case may be, whatever the case may be, whether it was police misconduct, whether they were looking into the concept that it could be a third party culprit,
Right.
that was not within the purview of ARCA either way. It
Right.
doesn't matter. Like the purpose that they were hired, independent of whatever the DOJ was actually looking into, whether it was one or the other or both, it had nothing to do with why ARCA was hired as far as ARCA is concerned. You know what I mean?
Yeah.
Oh my God, I got to get a bracket in. The
He's got to get a bracket in.
the NCAA tournament.
I feel like we
is-
should order food to be delivered while we're on this live and then alternate going off camera and scarfing food.
Scarfing or snarfing. I think
Snarfing.
you can scarf. Scarf is definitely a word as well. I think snarf or is it? Yeah, I scarf that down. That's accurate.
Yeah, okay.
I'm a snarfer.
You can snarf.
You can
I'll
scarf.
Uh,
But
I strongly feel that
I
is
concur
going to
with
be.
that. By the way, sister council, I think that's exactly what we do.
Oh, I was like, um, um, I forget what I was going to say. Oh, I strongly, strongly believe that motion, the ARCA motion, is constitutionally sound. It's a very strong and valid argument, and it will be strenuously appealed if she, as she suspected she would do, denies it. I just don't see why she's not seeing that issue. I don't understand it, and that I'm shocked that another lawyer thinks it shouldn't come in. But the problem is she is just not on board with the concept that they didn't hire them. Like, because the way she reacted about the, not being the candor thing. It seemed to be some of the comments she made seemed to imply that she thought that there was a relationship and it wasn't independent and that all of those things were true.
Yeah,
Um,
I know.
all right. What do you people in the world think? Which one of these apps is less fees? It's ridiculous. So they charge more for the food.
I have the DoorDash pass, so we don't have
What?
to pay. I've
Why?
had
We
that.
don't order it that you
I
have
think I think I got it when we were in
New Orleans.
no, in Miami when we were ordering the tabbouleh when we were getting the Mediterranean food.
Oh, well,
Remember?
then you do it.
Remember we were on that big time. You got to send me your order. It's so daunting because
It
our
is
orders
daunting.
are so complicated. Like I don't
And
want
you
to
have to
do it. I
decide where to
prefer
go. I
just
don't think
give you my
syrup. I don't think
phone
syrup delivers, but that place in
independently. No, they
North
don't.
Aurora does.
What do
No,
you
I mean
mean?
through DoorDash. I don't know if they're on DoorDash.
What?
Oh, I think they might be, but it was like outrageous.
It was?
Yeah, but you have the thing. So, but I was starting to say typically, and I think even if you have like whatever, you sign up with them, you might not be paying delivery fees, but the food costs more expensive than the menu cost of food. The price of the items are
Yes.
higher
It's outrageous. They jack up the price.
on all of those apps.
No,
And
Lisa,
then,
it's not over. They're on break,
oh,
which
they're
is
back.
ending right now.
All right. Well,
Perfect
you know what
timing,
I
Lisa.
like, so do it.
Oh, no, you got to send it, girl. What do you want? The Denver omelet subbing out the
Ham for
ham
sausage.
for sausage?
Or you know
Before
what?
we begin, um,
I just watched
realizing how much
Mac.
everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I
Sounds
didn't
like
make
she's
arrangements. I just
denying
want
the
to make sure that
motion
we're
then.
very well defined on what issue is before the court that would justify a voir dire. I just want to make sure, I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire?
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Do-
I mean,
does
she's
that work for
denying
the
your motion.
Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
Look, Bob picks up. He's like, oh. Alessi's talking.
Love me some Bob Alessi. Number one is he goes by Bob, which is amazing.
Not Bobby.
two.
I thought people were calling him. Oh, that was just you calling him Bobby.
And two, he is also a paisano. Hey, love everything about him.
May it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan
Wow.
on doing that or are you
Wow.
just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
What a
Wow.
In my presentation today, Your Honor, I'm going to,
tell you what I'm about to tell you.
I'm gonna
just so
tell you what I'm about
Your
to
Honor
tell you.
has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation,
Okay.
what the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide four parts of
telling
Canavan.
him what he's going to do.
Number one, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative, that's the ipsi dixit, comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Dalbert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion, "her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, "At trial, this court will require the Commonwealth's firearm arm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is quote, essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. Okay. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. there is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giuliani conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Daubert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giuliani's methodology or experience. Instead, it appears that Giuliani designed these experiments on his own without any guidance. Reading down below, quote, Giuliani's experiments also do not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giuliani did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula. Because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus.
What? That's what he's relying on?
What he's doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it.
So, I mean, your analysis
Right.
depends on the veracity of the witnesses.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon
think
Mr.
she
Brennan's
did.
answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanettes 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say
Or
no
rely on it.
evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation
This is
of
exactly
evidence,
what I was
etc.
saying about
It's not
ARPA.
for a biomechanical
Exactly.
engineer. Then he goes on
Right.
to
But they didn't do
2C.
because they shouldn't be.
Testimony of Jen McCabe. That's his heading.
This is
Karen
exactly
Reed
what I was
stated to
saying
her,
about ARCA.
et cetera, et
I heard
cetera.
that part.
In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top,
Pause it
and
real
this
quick.
is C Romanet
Babe.
1-1, 42622 Julie McCabe.
So, I mean, I hope that Alessi makes the argument that, and maybe she'd say that that's for cross-examination, but I mean, these would be amazing cross-examination points. So your entire analysis is dependent on these facts being true, on the veracity of the witnesses, on this, it's absurd. And not only does it, like you were saying about it's exactly what you're saying about ARCA, it just shows how inept the Commonwealth is being about how, well, the witness didn't know this and the expert didn't know that. Those aren't things they're supposed to know. All right. Say it. Thanks, Mandy. You only need to go back one little 5-second blip.
And this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes.
Wait
It's
a minute.
testimony. It's
Wait a minute.
testimony of lay witnesses.
Is this a true statement?
Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer.
Factual, I guess, not true.
Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a deceased? They don't exist.
Nor does he know the condition of the tail light at the time of the
And
contact.
that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, et cetera, of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist, he's not a hydrogeologist, he's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence.
Right.
And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the
rock hard ground?
He would not be offering a cause of death.
Then none of what he's in there he's going to be
The
saying?
spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one. Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure your Honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. Okay. And you can rely on that to talk about how that might affect the taillight. But frozen ground, we agree.
Agreed if he's put some...
We have no objection to the air temperature testimony of Dr. Welter.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie Nagel and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that? What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H. Romanet I. So with regard to Dr. Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit.
Hard to deny
so
that.
With regard to the experiment, The case law is clear, as I have recited. With regard to this experiment prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintolo talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request
to say the rest of it.
That because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are
Why
different
did you let it
demonstrations
in?
that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to ARCA's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to use it.
Do you intend to use all 140 or however many?
No, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm, and also we would want to
He
show
survived
the
such a thing?
Blaze locations
He
based on the
lived
data that
through
will
it?
be introduced through other witnesses.
After the pirouette?
After it's been attested to and its reliability.
Oh man, I hope he pirouetted in there.
Okay.
I mean,
If I may be heard on that?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right, so this will have to be provided to you prior to it's done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
Why did he
You can
not?
have them by Monday.
Okay.
And Your Honor, if we have an issue, still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure, so you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay.
Jackson was just sitting there thinking, God, I love Bob Alessi. All right, I'm about to bring you a special treat.
Oh, please. I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but the case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case.
Because they're not supposed to.
Obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll
But he
testify
shouldn't
to
have
that
relied
herself,
on it
that there was
in
no damage.
forming
In
his
fact, all the
opinion.
witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2-1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That
No
wasn't
evidence
tethered
they
to a
didn't,
specific study.
asshole.
That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on his study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept, it's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they're giving. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis.
Not the same science.
And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until.
He's not
We
an
have all that
investigator.
evidence,
None of
and
those
as a
factors matter.
Engineer,
Force and
he can
velocity.
consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that
No,
car is important.
it's not.
This is all science and
Not
data. It's
Not for
witness
biomechanics,
testimony. It's
buddy. None
science
of that
and
shit
data.
matters.
And it puts that car at that flagpole at the time Mr. O'Keefe is there with
Doesn't
his cell
matter.
phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And
Doesn't
within
matter.
2 minutes, we allege this collision occurs. And there's Apple Health data,
Doesn't matter.
there's location data, there's
Doesn't
cell
matter.
phone battery
Doesn't
temperature.
matter.
It all coincides. He should be able to consider these things in his study. This is what he does.
None of that matters.
The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses.
That would be compelling if he's actually able to show that.
From the actual video?
Right.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm. And that is based
Sir,
on
there's no evidence the arm was bent.
engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to
But he relied on
present
them.
the demonstrations to support the opinions. as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard your response?
Sure.
Thank you.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He
Tell him.
didn't state or even address
Methodology.
where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it on a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis.
Right.
The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating quote, "This is what he does," referring to Dr. Welcher.
What is?
The question is not, is this what he does?
The question
is what he does rooted in science.
Right.
And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Daubert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Daubert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries. I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Daubert factors. So,
for sure.
In conclusion, Your Honor, I go back to Rentala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay.
I mean, he's right.
Go
He's
ahead, I'll
so
hear a
right.
quick response.
Like, please say something actually right.
I have such a massive law nerd crush.
Regrettably, I
on
know
Alessi
Attorney
and
Alessi has
Hayes.
decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements.
Yeah,
This isn't the first time
it was more
that
acute
Mr.
of a
Alessi has
judge.
tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not.
Hey, asshole, what's good for the goose is good for the gander. You've been doing it for months now. The same exact shit to the defense. The same exact shit. This guy is the biggest blowhard out of anybody that I've ever seen.
To mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alessi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful Attorney Lisi's joining the fray, and that is all part of the strategy here. Now,
Sit down.
if you look at page 13 and
Why is she
14 of
letting him ramble
Dr.
on with
Welch's
this
report,
bullshit?
perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're
Identify
talking
what part of them.
about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's
Oh,
all
so-
there.
So ARCA
Let's
does
hear
do
it.
it.
Let's hear it.
What?
All right.
He doesn't say what it is.
So we're going to move on to try and get some motions in quickly.
Oh, God.
The motion regarding the chalks.
Right,
Is
and?
there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583.
That picture just makes me crave hugs from
Is
my
there an
man.
objection to the Commonwealth's motion eliminate to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it unless you tell me what.
No, let's see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins,
I thought they said he wasn't
types of
putting that-
cases.
that,
So is there an
Aruba
objection from the
stuff.
defense on that? If there is, I'll hear it quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with
Jeez, as a
the
nephew.
defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear, based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident,
All right, so what's the time frame? It's so
And
over
what's
the course of the
proof that
day.
She heard it.
I realize that the Aruba incident is too remote and you're not using that, but what's your
Excuse
time
me,
frame for me to
Aruba.
be able to evaluate
as
this?
far as his messages, I will
Or the
look,
statements, or the evidence that you're trying to put in under this doctrine?
his niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay,
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
okay.
But you didn't give her the
And there would
time
be
frame.
nothing different from the last trial, other than the fact that we are not going to pursue the Aruba information. So it is actually a narrower time window than before.
Okay.
And
All
that
right, I'll
time
hear
window
Mr.
is what?
Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements.
Right, double
Or
hearsay.
potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range.
Right.
But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Ms. Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, quals, those points that need
Correct.
to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had what was considered, what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted
all you guys
by
are
even the
saying.
Commonwealth, that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, showed the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her, and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job.
Right.
Had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's
Right, to
no
make it
suggestion in
probative
the
of
facts
goddamn thing.
that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact
that she never did.
That if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her.
Or that she's
It's an attempt to inflame the jury,
you know how women
to make
are.
them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Pause it 1 second.
Yeah, definitely.
I think the Commonwealth's better argument is literally what Karen said on the on the documentary, that they could say that he went in, he didn't go in. So
He didn't go in where?
they're saying he didn't go inside, because I was gonna say that she was so angry that he left her out there for that extended period of time that when he finally appeared, she's like, I'm so mad at you, I'll run you over. But I wasn't thinking about the fact that relies on him having gone inside, which they're obviously denying.
They're never going to say that. The bigger takeaway from this is, if the second-degree murder charge goes away, none of this shit matters. None of it comes in. This is all intent. This is all mens rea for second-degree murder. It does not apply at all to manslaughter. So, depending on what happens with the First Circuit over on the federal track, if that gets bounced, none of this shit's coming in anyway, because it's irrelevant.
I suspect she's gonna. I doubt that that's gonna happen, by the way. But I mean, as far as
I doubt it's going to happen too. I don't.
But
I mean, that changes the law in terms of when a verdict is a verdict.
right, and forgot what I was gonna say.
Oh, it's that age thing. As
Yeah.
we get older,
What
sometimes
were we just talking about?
I don't know. I forget already. See, happened to me too.
I
I got
think
your back, girl.
I think I was gonna say, oh, I remember. So that I think that she will probably let all of this in, but even if she limits it, I think she'll let some of it in. Maybe not, but I'm done thinking like I'm going to give her the benefit of the doubt because the way, I mean, that last arc, well, and in any event, I just don't think it's that prejudicial to them. I mean, yes, it's prejudicial in legal theory, but I think that all the things that he just said, he'll be able
Oh
to
no, I thought it
establish.
was highly prejudicial. Them playing the voicemails, like you even saw it here with
Oh, well,
polygraph
that's
talking
different.
about.
They can do that. That has nothing to do with this aspect. Her
What do you mean?
voicemails.
The angry voicemail she's left?
Yeah, but that's not about his state of mind. That's not the people saying he
No, I
wanted to break
know.
up with
I
her.
know, but it's a accumulation type argument because all of it is being used just to assail her character
Yeah.
to show that she. I mean, any woman or man for that matter who's just dropped their significant other off at a party and you don't hear from them for 2 hours and you were taking care
Oh,
of that person's kids and they're ghosting you, you're going to be
I'd
pissed.
be fucking infuriated.
I know.
I
I
would have
know
just
that's
taken my ass back there, barged right in the door and said, "Are you fucking
that
kidding me?"
that's exactly what would have happened with my wife.
Uh,
Forget the well, the first would have been the angry emails and then the trip back to
right. I mean,
34
assuming
Fairview.
that you just literally went inside, said, "I'll be right back," and then never came back.
Or either way,
Right.
even if I didn't say that and
Well,
you're
I
hitting me
wouldn't
up,
be
you're like,
as
dude, it's 2 hours later.
I mean, I wouldn't be
Uh,
as upset
the
2
kids
hours
are here.
later, you're with friends.
I think you'd be pretty upset. I'd be
No,
upset.
I mean,
I'd be like, what is this fool not answering my shit for?
yeah, I would have just texted one of your buddies and been like, "Can you tell Bob to look at his phone?" You know? But if
Yeah.
you were supposed to come back out for me, that's what I'm talking about. Like, I'm in the car, you are like, "All right, I'll be back," and then just leave me out there, and I leave, whether it's, like, just to be a bitch about it, and then that, dramatic thing I decided to do of just leaving didn't prompt you to call me and be like, "Hey, I'm sorry. What," like,
Where
"Come
are
back."
you? I'm
Right.
standing here in the curb. What the fuck, man? Yeah. All right, let's see what Brennan's gonna snivel about now. Is he gonna be
It
offended
seems
how
the
the
thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes.
Well,
She
that's
was
accurate,
asked
buddy.
by Ms. Voss on June 20th, 2023 about that night or the day before. And she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep.
See, that's after the fact. That's
After the
exactly
fact.
that's what
What?
that's what I'm saying. They're mixing their metaphors here.
Right.
You know what I'm saying?
And
Like
I'd
they're
like to
using it
know,
cumulatively. That's
if
exactly
you
what I'm
just
trying to say to you.
murdered the guy, why are you mad at him for not calling you? Why are you
So
mad at him?
all Jackson has to do is stand up and say, that's after the fact. We're talking about John O'Keefe's state of mind, and that could only exist when he's alive.
And in my opinion, all of her anger after she's supposed to have killed him for not calling her for, is proves is exculpatory. And I thought their position before was like, oh, she just made those phone calls to cover up for the fact that she just killed him. I mean, which way are they having it?
Oh, they
They're not
want it both ways.
well, you can't right,
Yeah.
exactly.
Can't have their cake and eat it too.
Oh boy. Let's see what
Now,
this
in
says.
addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision.
Again.
And so we have
doesn't think she's
statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive, without reading them because it's unnecessary. There is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible.
No idea when John O'Keefe
other.
died. None.
Your Honor, if I could just correct the record very quickly.
Sure.
If anything Mr. Brennan just said was true, he might have an argument. My goodness.
Exactly.
It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day.
Correct. In the
It was
morning.
the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I read the I wasn't there. I read the transcripts." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
Well, before he was found.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done.
Yeah, sit down, Hank.
This was during
Relax,
the time
big guy.
after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact.
In the morning.
The other
called the
issues
morning.
concerning
She's still wondering where
Karen
he
Reed's
is.
statements about being upset, or in Gretchen Voss's words, were you pissed at
After
him?
the fact.
It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts?
Again.
Yeah, I did. No, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
So, oh Lord.
Oh,
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard, totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact,
That is not what she said that night, you dipshit.
Right. What is his
She's giving like
reasons why how she's
giving
getting
a
to I
frame
thought
of
he
reference to the reporter asking her a question. And that is not a conversation that took place last night. This guy is so full of shit.
and
Oh,
answer me this. If she has unalived him, she had the forethought to pretend to suspect he may have walked to another woman's house just to cast down, shade away from the fact that she has intentionally slaughtered him.
when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband.
Still
That's in the morning, buddy.
Not my words.
That's
in the morning.
after.
All right. So
Wait, no,
we're
somebody
going
needs
break.
to say it.
We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on, both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2
Your
o'clock.
Honor, if I could, as the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it. Yeah.
He should have just said, try. I guess he couldn't, right? So,
Right, she shut him down.
Right.
Shut him down.
Brennan is, he's like an absolute fool. He honestly does not know the case.
He really doesn't.
This is shocking.
It's either he doesn't know the case or he's just that slippery.
Oh
Or
my God.
both. Or both. Either way, he's making misrepresentations to the court that he should
Right.
know.
Right. And we saw that I keep wanting to say that it was the
Her words, not mine.
Right.
So, I'm hanged by her words.
what it wasn't was it Young Thug? Where the judge was like, either you're like literally incompetent to such an extreme degree, or this is intentional, like.
All right, so we got an hour.
Bukkake.
Should I make another live?
I think so.
What do you guys want to do? If we're gonna leave it on, Allie and I are gonna dip.
We going
Or
dead.
we can leave the chat. We can leave the chat on if you want, or I can create a
Wait,
new live.
before we go, there was a really good comment, and I apologize so much to Kaylee because she actually did a super sticker and somehow I missed it. And it goes back to ARCA and the motion about what they can say about ARCA. I 100% agree that even saying you were hired by a government body would be like enough. And I wish they would have maybe proposed some other options in light of her being Judge Cannoni's statement that if I were to grant this, and I'd be surprised if I would, comment, but I do think that they could say you were hired by a government body, and that would at least alleviate the problem of somebody assuming that it had anything to do with, someone associated with Karen Reed, or who was motivated to make findings that favored Karen Reed. So go ahead, babe. Sorry about that.
Oh no, I wasn't saying anything.
No, I know. You were deciding what people.
All right,
wanted to
so
do.
I think what I'm gonna do, Tracy, I think I'm gonna give our mods a break. That's something that I don't think I take into consideration. I think our mods may want to take a break as well. And I think that they rightfully think that they need to hang in chat just to moderate. So I'm going to create a second live. I'm going to portal everybody to it. We'll start 5
Man, he's
minutes
like, I just
early.
woke up. I'm fine. He says, let's go over have you talked about the Koberger docs? Because Lisa,
Babe, there are so many. There is no, like, it's going to be that's going to be a 5-hour live.
well, you could at least say that one thing that main thing that you think, that seems nail in the coffin for.
Well, look, no, I want to go through all of it. I want to
All
go
right.
through all of it. I mean, if you
Sorry.
guys haven't seen the docs, it seems that there's confirmation that Koberger bought the knife and the sheath on Amazon. It seems
And then
pretty clear to
search
me.
for a new
And
one.
then and that
afterwards.
was in March, and then in November after the homicides, he went back on and was searching websites, various websites for the same knife and sheath. Presumably, the concept being that he
Replace the one
would,
you left behind.
right, he's got to be, he's like, if they come to him, he's going to be like, oh, I still have the sheath. It's right here.
I mean, I would think there's probably a lot of people switching sides after.
I mean, they're like,
Oh.
maybe not. People are going to be like, oh, well, it's,
And
look,
it's not about
all I'm
switching sides.
telling you.
Still stay open. Right.
Yeah, look, I'm talking strictly from the perspective of a jury always. Like I never reach a final conclusion till trial. I can't say that more than I already say it. But in terms of a jury, he's done for. He's done for. I'm sorry, he is. If you think that he's not the guy, having the sheath with his DNA there, and they're not going. And from what I've seen in the filings, they're not going to be able to attack that. I heard people like in the past months talking about how they found it way after the fact. It doesn't sound like that. Sounds like they found it immediately. And when you have him buying the same yeah, right. Yeah, blame Allie. She got me on. I don't want to talk about Kohlberger now. It's like a
No,
whole
I just
thing.
thought there was that one piece we could share that was.
Yeah. And yeah, like Richard Allen, Karen Reed, and Brian Koberger are all completely different cases. Completely different
Right. You're
cases.
going to find that the comment or the state, the government, whatever, they reach in almost all trials. And it's, I would say it's to their detriment, but at the end of the day, they also almost always don't see a detriment. Um, because, even when there's evidence that someone is factually guilty, like take the best example, at least for me, is OJ Simpson. I believed it was very likely that OJ, I now believe OJ actually did commit the murders, but at the time of the trials, I believed, oh yeah, it's very likely that this guy did it. Seems like, but as soon as all that evidence of police tampering and the racism and the lies and the evidence, there's now blood there that wasn't there. There's now this there that wasn't there. I'm like, I don't care. I don't care. That is it. You have damaged it all, and now there's reasonable doubt, no matter what, even though I thought he was factually probably guilty. And, as a lawyer and and this was even before I was a lawyer, but just having that kind of mindset of I don't need to think someone's factually innocent to be outraged at what's happening to them, to think the trial is unfair, that, all of those things. And I understand that most of the public probably do. They're like, well, I don't care what's happening to this clearly killer type person, you know, but when, so I think that there might very well be some, um, whatever it's called, what's the word when they're reaching or plant not like that they're stretching the evidence in Koberger doesn't mean that there's not you know some evidence to suggest that they have the right guy.
Sorry, babe. I'm barely listening. All right. So I've set up the new live and I am portaling everybody to it. So you don't have to try to find it. So frankly, if you want to chat, you could chat in there. The mods don't really need to be hanging out in there. So, and as a reminder, if you're not going to be joining us for the afternoon session, remember 5 o'clock Central Standard
It's a
Time.
big one. I hope you've
Big
been
one.
pushing that.
Yeah, we got Andrea Burkhart and we have Richard Allen's digital forensics expert that testified at trial, Stacey Eldridge, joining us. It should be a fabulous live. We hope that you guys will all hang there with
And
us.
did you put up the members question thing? You know, people
Yeah,
can-
if you guys, I'm gonna do that. I'll do that during the break. I'm gonna put up a something in our community page. If you guys have questions, because I'm not going to take questions from the chat while the live is going. So if you guys have any questions, burning questions that you would like us to consider to ask Stacy, let me know over there. That's the proper place to put them. I promise that I will look at them. And if there's anything that we're not covering between Allison, Andrea, and I doubt it. We'll probably get to all of it, but you never know. You never know. All right. So I've already hit the portal. We love you guys.
Love you,
Thank
Jay.
Yeah, love you, Jay. Thank you guys for your generosity. I think we gave you guys all the love during the live. We appreciate it.
Oh, wait,
Lisa.
but you didn't give her, you didn't say hi to Dana.
Oh, welcome to the family.
That
Family
was the
hug.
last one. Oh, wait,
Aw.
I think one more.
Curious Liz. Family hug. Welcome. Love having you guys. All right, we'll see you guys at 12:55, my time, our time. Love you.
Love you. I mean, bye.